So when we break it down a little bit, healthcare powers of attorney, in my mind, this can be one or this can be several documents. There's no right or wrong way to do this. But the components that you need to have as part of this kind of healthcare proxy includes the appointment of a healthcare agent, someone who can make those choices for you for health, medical decisions, whether you can stay in home for yourself, how to make your home safer. And that's where your healthcare agent may be working with someone like Sue on my team to decide how can we make the bathrooms a little safer to stay at home. Do we need ramps to get in and out of the home? What about better lighting on the stairs? That healthcare agent is the person who, with the doctor's recommendation, can make these decisions for you, especially if you can't make those choices for yourself. You want to include a HIPAA authorization. You all see these at your doctor's offices all the time. But you want to have one that's general, that allows people of your choosing to receive health information about you. Otherwise, just your agent would have the ability to call a hospital and ask about you or speak with your providers about you. The one thing people always ask me about is a living will, and they call it a DNR, and it's not the same document. The DNR is a medical physician-led document. The living will is what people often will come to me and say they need. The living will is where you get to identify your wishes for end-of-life care and treatment. How and when you want that treatment to be handled, under what circumstances, if you were terminally ill, or if you had a permanent coma, or if you had advanced dementia. How do you want that life-sustaining care to be met, to meet your needs or your wishes? Because your agent, your healthcare proxy, they may not know those wishes, and they want to do everything they possibly can to make sure they're following what you would want. And so having that document, that living will outlining your wishes is so vital in making sure that your preferences are followed, or at least expressed in a way someone can follow those for you. I always reference the idea that unmarried people should have a healthcare power of attorney, especially because if you are unmarried but you're in a committed relationship, that partner, that person that you may trust, that person that you may want to make decisions for yourself has no legal ability to make those choices for you without this kind of document. And so this becomes especially important for committed partners who are choosing for whatever reasons not to get married, but they want these people to make choices for them in their lives. This would especially be true for other people who don't have close friends or family members that they want to trust or would want to burden with these kinds of decisions. This is where you get to outline your wishes for these kinds of people that you're identifying, or organizations to step in and make these choices for you. We talk a little bit about what happens if you don't have a power of attorney for health, and the alternative is nothing happens until something happens in your life and someone believes that it's unsafe for you to be home, perhaps because you have diminished capacity, perhaps because you have a diagnosis that is creating some living conditions that makes it unsafe in someone's eyes for you to continue to age safely at home. So nothing happens when you don't have this document until something does. And that usually involves adult protective services coming into your home to investigate. It could be a neighbor who calls social services because they have fears that they've seen you wandering lost in the evenings. So then, what happens when you don't have that document, when something like that happens, then you're looking at a court-appointed guardian and guardianship proceedings. These can be sometimes physically taxing on you to defend, or they can be taxing on your family members in pursuing. Sometimes they're financially burdensome. In all cases, it can be a public proceeding that results in a court deciding some of these decisions that you may not have decided that way for yourself. You may not have appointed someone to serve as a guardian. You may have preferred someone else. So the whole ability to have this document gives you that control. Now, the counterpart to the health power of attorney is the financial power of attorney. This is one that you also appoint an agent. That's where you're appointing someone to handle your finances for you. And it's not limited to just finances. It could be allowing that person to handle real estate transactions for you, filing your taxes for you. People who want to age in place sometimes have long-term care insurance policies. This agent is the person who may be making a claim for those policies on your behalf. This person may access your retirement plans on your behalf to receive your annual or RMD, those distributions on your behalf. So this person isn't limited to just handling a bank account. This person can do quite a bit. This person can buy vehicles for you or sell vehicles for you. And so truly this agent has significant control over the things that are truly valuable in your life. All the more reason to appoint someone in this role that you trust, because you can be granting them some power that you want to be careful in who you're handing that power to. So I see quite a few powers of attorney that are pretty much one sheet, maybe 2 sheets, 2 pages. And these have just like a little checklist where people initial, I want real estate transactions to be done. I want insurance and bank accounts to be handled by my agent. Those are very helpful in giving the kind of authority to your agent to handle those things. In my world, as an elder law attorney, I refer to these as short form powers of attorney. They can serve a good purpose, and that purpose is typically avoiding guardianship. When we are talking about meaningful long-term care planning, these short-form powers of attorneys don't get you very far. These short-form powers of attorney are not going to have some of the complex gifting powers that we may want to see for long-term care planning. Because when we're talking about planning for long-term care, we may be talking about asset preservation, being able to preserve what you have and make it last as long as we possibly can to continue to meet your needs, especially if you have longevity in your family, or especially if we can predict that you have a particular care need that could be expensive and keeping you at home. We want to preserve assets to be able to provide for that. So asset protection can take different forms and have different meanings for different people. If you have a more basic short form power of attorney, one of those little lists that people just initial, that kind of short form power of attorney is not going to give you the ability to preserve assets. It truly will have the ability to use those assets, and that may be what your agent is limited to doing. So the more complex powers of attorney that I do want to see, I want to see the ability to make gifts, and sometimes we want to have limitations on those gifts or parameters surrounding gifts. Why gifting is so important, we're coming back to that when we talk about Medicaid planning, particularly when we're doing crisis planning, where that is a tool that we may use to get money out of people's hands very quickly to accelerate eligibility for other public benefits, maybe like VA, maybe like Medicaid benefits. So being able to make gifts can be an important aspect in a power of attorney that you may want to consider. Other abilities or other complex provisions you may want to see in a power of attorney is the ability to change beneficiaries on life insurance or retirement accounts, because the idea of leaving those assets to a surviving spouse who has dementia may not be a safe idea for asset preservation. We may want to leave those assets in a more protected way. Perhaps we want to be able to change rights of survivorship on real estate as a way of preserving real estate property. These are all things that you would want to talk about with an attorney to decide whether this is important for you or not, because these are completely big options and require quite a bit of discussion. But truly, the more complex powers of attorney have an element of long-term care planning that you may want to consider as you're planning. Other options that you may want to think about in your powers of attorney are whether we want to allow your agent to act immediately, or whether we want that to be more contingent or springing upon your incapacity. Those are all important decisions that you would want to talk about with your attorney in selecting who your agent would be to act on your behalf. I do see quite a bit of out-of-state powers of attorney, and people will always ask me, is this still good in North Carolina? And we'll talk about, actually, I would have to read the document that you've got to determine whether this is something that would be accepted here in North Carolina. Does it refer to the other state statutes? It may. I'm not licensed everywhere. We don't always have attorneys who are licensed in those other states. So sometimes as a matter of efficiency, it can present some complications in having an out-of-state power of attorney with references to another state's laws. You may need to have an attorney with that license in that state guide your agent through what they're permitted to do. So those are things that we would want to talk about, whether the one that you have still meets your needs here. One of the biggest questions I get is, do I need a power of attorney? I'm just going to add my kid to my bank account. And I think that is a horrible idea. I always have a few clients tell me that they didn't know that. And so I'm telling you now, it's a bad idea. Adding an adult child to your bank account with you can spell quite a bit of trouble, both for you and possibly for them. For one, they can steal from you. And nobody ever wants to imagine their adult child stealing from you, but that can happen. You'll tell me, oh, no, I trust my son or my daughter. The other aspect is that they may unintentionally steal from you. And that may be through litigation, because lawyers litigate, and sometimes they litigate really well. If your kid is on your bank account and has your life savings in there, and your kid is in a car accident, whether they caused the accident or not, someone can still sue them. And that bank account may be frozen in litigation until they can determine that the kid probably didn't own a real interest in that bank account or only a partial interest. So you don't want your money wound up with someone else who you're not married to. Other reasons that you may not want your child on your bank account with you is if you don't like your kid's spouse. Your kid may have a power of attorney that names their spouse as someone to access the things that they own. And if your kid's an owner on your account with you, that gives your in-law the right to handle that asset for you. And so that may be another reason to avoid having your kid on your bank account. A more benign reason not to have kids on bank accounts, I only have one kid, so he's my number one son, and my favorite, of course. If you have more than one child, but you've only put one of those kids on the bank account with you, you may have effectively disinherited the other kids. And that may or may not have been intentional, but that's where these are some thoughts that we want to pursue before we have people join you on assets. And truly, that's where having a power of attorney is much more effective in delineating the roles between agent under a power of attorney. They're going to be acting as your fiduciary. They have to do things correctly for you and in your best interest, versus them as an owner on your bank account where there is no real control or oversight on what they can do because you've given them that ownership. So those are some things to think about. That's one of the big questions I always get. So this document too, this is a foundational document for long-term care planning, mostly for some of the provisions that we are allowed to do within it. Whether we have the ability to transfer assets, give assets away, or really add people to assets under the right conditions, this is the foundation of long-term care planning. Because if you're not able to do that plan for yourself, then we're going to be looking to see what this document allows and who can do it and under what circumstances. Other question is, if you don't have this document, what happens? Well, nothing. If nothing happens to you and you die peacefully in your sleep and you've never needed this document, it was a waste of everyone's time and energy. But if we do need it, it's too late to get it if you have diminished capacity. And we can't predict when that's going to be. We can't predict strokes. We can't predict other circumstances where medications impact our capacity. And so having this in place is a great planning tool for the just in case. We talk a little bit about probate administration because if you have a will, it's going to pass through probate. That is after you're gone. That is not helping you age in place. But we may want to think about who we're leaving our stuff to. If we have a spouse who is going to be the surviving spouse, and that spouse has a diminished capacity, or they already are in position where they wouldn't be able to live at home without you. We need to do some significant long-term care planning to provide for that spouse's needs and ensure that those needs are going to be met even if you're not here. And once you've passed everything through probate, it may be too late. So going through planning with a will or a trust may be helpful in identifying how to meet that spouse's needs. Sometimes you may want to include a supplemental needs trust for a spouse or even any disabled person, an adult child who has developmental disabilities. And so being able to plan for your loved ones contemplates the idea of what's going to pass through probate. How are these people going to receive these funds? Are we going to let it go through the probate process, the court process? When you have a will, you have to go through probate through North Carolina. If you don't have a trust, or if you do have a trust and you haven't funded it, you're going through probate with your property. Here in North Carolina, our probate fees are not significant. They're capped at $6,000 for assets of $1.5 million or greater. Sometimes people on a fundamental level don't want to pay the probate fees. And that's when having a trust can be more effective. We do not have federal estate fees until you've reached $12 million or more, and that's per person. So most of my clients don't fall on that level. I actually refer them out. I work with people of more modest means. When you have probate that has real estate in other areas of the country or outside of North Carolina, you are looking at two probates, one here and one in the other state. That's called ancillary probate. And that's when, if you have property outside of North Carolina, you may want to start thinking about a trust or other ownership options to avoid those probates in both places. So that's where a trust can come in handy. A revocable trust is a great tool to avoid probate. That is helping people age in place by avoiding some of those probate fees. It allows you to fund the trust with property now during your lifetime. It is a living trust. You can put bank accounts into that trust. You can put real estate into that trust. You can transfer quite a bit of property to that trust as a way of avoiding probate. That is something that you have while you are still alive. Typically, it's a trust that you can serve as trustees for yourself. And you can still treat it like an estate planning document where you identify beneficiaries to receive these assets for you after you've passed. Some of the benefits of having a trust is that if you have funded it correctly, you are avoiding probate, you're avoiding the probate fees. More importantly, you may want to be providing for people in a certain way. So if you're like me and you have a minor child who might inherit from you, that minor child should also have their shares held in trust for them, at least under certain parameters. For me and my son, if he's 25, he doesn't get any money unless it's for school or health reasons. So there are people in your lives who may be inheriting from you. I think about this as a dollars and cents discussion. When should your loved ones inherit from you? When and how? Under what parameters would they be able to receive money? Who's going to handle that money for them? If there are people in your life who may be receiving funds but we're holding it in trust for them, that's when having a revocable trust for yourself is helpful in funneling the money, avoiding probate, and then passing it to that trust for your loved ones. These kinds of sub-trusts that we talk about too are not only helpful for minors, this is helpful for a spouse who may be a surviving spouse who's disabled, who may be eligible at some point for benefits, or who may not be able to live at home alone without you. These kinds of sub-trusts are also helpful for adult children who may be inheriting from you and you don't like their spouse. Or these may be for adult children who are financially irresponsible. And so there's different reasons to have a revocable trust simply so that you can funnel assets to a sub-trust for these loved ones or these heirs. So when a revocable trust is important, it's because you can funnel things like retirement accounts or insurance policies to a revocable trust on your death. We've talked already about funneling assets for minors or disabled people, heirs who may need help handling money, to provide for kids and spouse and blended family situations, making sure everyone's needs are met no matter who dies first. And then that out-of-state property, if we have property in 2 or more states, this is where you would fund the trust with your property and avoid probate in both states. This is helping your loved ones avoid the hassle and the hurdles of going through probate and the fees of going through probate. This also allows your executor or your loved ones to avoid any claims by creditors against your estate. So those a little bit were some of the estate planning elements that are also foundational for long-term care planning. No one chooses purposely to live in a skilled nursing care facility, and most people don't intentionally choose to live in assisted living. With that said, I learned of a staggering statistic the other day at a conference where about 60% of the people over 65 will end up in some form of long-term care. And an older statistic referenced that people are in long-term care for about 3.5 years. And so that's when being able to plan for that kind of care, even if that's not what we choose, that becomes very important, and it should be intentional. I meet with a lot of families who they say, well, we don't want to go into long-term care, and I agree. And so living at home is always everyone's preferred means. And so being able to plan intentionally for aging in place is truly important. You may want to consider private pay options that have caregivers come into your home and help you. That can be incredibly expensive. I would wager to say you might be looking at, if you needed 24-hour care, that could be $20,000 a month. And I think that's probably on the low end. It depends on what your care needs are, but certainly private pay allows you to stay at home if you have the means. Long-term care insurance, that's another means of being able to age in place at home, and it's truly a helpful tool when you have it. I encourage everyone to have those notices of premium payments sent not just to your home, but to the home of your power of attorney, so that if you have to pay monthly or annually or quarterly for these kinds of policies, that those policies don't lapse for non-payment. If you have a policy for long-term care, it's a valuable tool, especially as you age and especially as you want to age in place. So I would encourage your agent under a power of attorney to also receive those notices of premium payment, so that if the mail doesn't get checked because people are in the hospital, that someone will notice and pay this for you to keep that policy in place. Paying for long-term care insurance, I know, can feel like a burden, and I think it's one of those things that if you've chosen to get it, it can be a real helpful tool to allow you to stay at home. Different kinds of policies allow for caregivers to come into your home. Some policies don't provide for assisted living, and so as you are looking at policies, that may be a factor you want to think about. Most policies do pay for skilled care. Some policies allow for personal caregivers, but they don't allow for family members to be the caregivers. And so as you are looking at long-term care insurance, you want to think about what's important to me, because it all truly enters into the premium price that you're going to pay. I don't sell long-term care insurance, but I can review the policies, and I can certainly make recommendations for you to meet with people who do sell those policies. And we can talk through what might be important to you as you're making your plan for long-term care. We just celebrated Veterans Day, and if we have veterans in here, I thank you for your service. There are certain veterans benefits that are available to wartime veterans and their spouses. Some of these benefits allow you to age in place at home and have some of those care needs met through a special pension called Aid in Attendance. This is a benefit that you don't automatically qualify for. You have to apply and be eligible for. Aid in Attendance can pay for roughly $1,700 to $1,800 a month towards a veteran's care needs. A spouse of the veteran can receive roughly $1,300 a month towards that spouse's care needs. These are things that you have to work to qualify for, both financially and on an income level. To qualify for this aid in attendance, the VA does look at household income, so that would factor into part of that decision, as well as the assets that people own. But that is certainly something you can receive at home. You don't have to be in a facility to receive aid in attendance for your care needs, and that can certainly help defray costs. The last bit of being able to pay for long-term care is actually Medicaid or special assistance. And most people I talk to will say, well, I'm not going to qualify for that, so I don't need to listen to this part. Medicaid or special assistance is a public benefits program that if we needed to qualify people for, most of the time we can get them qualified within a certain amount of time. It may mean we have to spend money down to qualify, but there are planning tools in place that would allow us to qualify. Now, if you're planning to age at home, then these may not be benefits programs that are going to be incredibly helpful for you. Medicaid doesn't typically cover care at home. There is a Medicaid program called CAP-D for aging and disabled adults that does allow for home services. However, the list to get on those benefits can be a lengthy waiting list. And so that's not something I usually will advise my clients to plan on. If they do qualify and their number comes up, that may be something that is able to be used to age in place at home. But it isn't something that's a guarantee and certainly shouldn't be counted on. Special assistance is a program for assisted living, similar to Medicaid. It's sort of like a step cousin or step sibling to the Medicaid program. Both of these programs for public benefits require eligibility in meeting some financial parameters. And so we are going to talk a little bit more about these programs. A lot of times people will say, well, I'm just not going to qualify. We have too many assets. And truly, we can accelerate your eligibility if it were important to you. But the real reason to think about and at least know a little bit about Medicaid planning is because people are living longer than other generations. And you may outlive your money, especially if longevity runs in your family. And so being able to plan for you to stay in place as long as you possibly can is important. But if you do run out of money and you have care needs that can't be met because you've run out of money, you need to know that there are options available. I also bring up the prospect of Medicaid for couples. A lot of times I'll work with couples and they'll say, well, we're not planning on needing Medicaid or long-term care at all. We're going to stay at home. And I think it's worthwhile to at least think about, because there are times a spouse has dementia and starts to wander, and the other spouse who is very physically capable of handling things at home may not be able to keep up with someone who wanders. Or if you have a spouse who is exceptionally tall and you're a short person, if your tall spouse falls, being able to pick that person up as a short person can become difficult. So living at home starts to become unsafe for couples, even if your intent is always to provide for each other. And so there are times that we do need to think about other options besides just living at home, especially if it can become cost prohibitive to receive care at home. So those are some of the reasons. Why do we want to think about qualifying for Medicaid? The myth is that Medicaid is just for poor people, and truly it's intended to be for people of limited means, and how you reach those limited means depends on the quality of planning you do for long-term care. Many times people will run out of money because they live too long, and so qualifying for Medicaid is something they may need to know about if their money runs out. When we are working with families, we're working with them in two ways. One is proactive planning. That's where we're planning around what's called that 5-year look-back period, and we're going to talk a little bit more about that in a few minutes. Or we're doing crisis planning. And while crisis planning doesn't sound fun. That's what most of our clients are doing because they weren't proactive when they received a diagnosis, or they weren't proactive years ago in getting planning done. And so proactive planning allows you to be able to protect more assets. Proactive planning allows you to be able to identify without urgency what those wishes and preferences are. This allows us to be able to plan to stay at home as long as possible, or allow a spouse to stay at home even at the expense of someone else's care needs. And so that's where proactive planning can be so meaningful for families and couples. Proactive planning allows you to protect the spouse who stays at home. And the benefit is that this proactive planning allows you to provide gifts for your heirs, even if someone has been in long-term care or needs long-term care. So we focused a little bit on how to qualify for Medicaid. Truly, there are 3 ways to qualify for Medicaid, or 3 assets or facets of qualifying for Medicaid. One is that you are medically eligible. You qualify for the level of medical care that's necessary for Medicaid or the Special Assistance Program. Typically, that requires you to be in a skilled nursing care facility. For special assistance, that would be an assisted living facility. You also have to financially qualify. And this is where the assets for couples and individuals will differ. If you are an individual looking to qualify for Medicaid, you essentially have to spend your monetary assets down to $2,000. You may have a car, you may have a home up to, I think it's $605,000 in equity. If you have more than one piece of property, that other piece of property would have to be sold and spent down. If you have more than $605,000 in equity in your home, that amount of equity over that dollar figure would also have to be spent down, or you would just be denied Medicaid. So as a single person applying for Medicaid, there are some things that you just can't have. If you were a married person, then Medicaid looks at the married couple's assets as a whole. It doesn't matter whose name is on an account. It could be all in one person's name, but Medicaid looks at the couple as a whole. Medicaid does not care if there was a prenup in place years ago that says what's mine is mine and yours is yours, and we don't pay for each other's care at all. Medicaid doesn't care about prenups. Instead, they look at everything that couple owns. Now, the person in that couple, one of the spouses who needs care, they still have to spend their assets down to $2,000. The spouse who stays at home, we often call the community spouse. The spouse, that person does not get to keep everything. They get to keep about half of those assets that the couple owns as a whole, which means about half the assets have to be spent down to qualify for Medicaid. And how that spend down looks, we're going to talk a little bit more, but that's how you financially can qualify for Medicaid. The third facet in qualifying for Medicaid is that you can't have made gifts in the last 5 years. That is what is commonly called the 5-year look-back period. And so we're going to be talking about some of these facets in the next few slides. So our exempt assets, these are things like the home with the equity up to $605,000, one vehicle, not 2, but just 1, a prepaid irrevocable burial plan. That's an option that's an exempt asset too. Everything else is non-exempt. IRAs, life insurance with cash value, bank accounts, more than one vehicle, more than one property. All of these are things that have to be factored in so that they either have to be spent down, or for married couples, those assets have to fall into the ledger of that half that the spouse at home, that community spouse, gets to have. One more thing about that community spouse, they don't get to keep the whole half unless those assets are maxed out at $137,000. Anything over that would also have to be spent down. So I referenced that 5-year look-back period, that third facet of qualifying for Medicaid. That rule is that In the 5 years preceding a Medicaid application, you can't have made gifts or transfers before and expect Medicaid to pay for that. So that 5-year look-back period prohibits gifts from the couple to anyone else outside of that couple. And so we can make gifts to each other as spouses, but we can't give the house to the kids and then turn around a year later and apply for Medicaid. You can't go pay for your kids' dental bills. You really can't pay for other people to do things. You can't pay for your kids to put a new kitchen in their home, because those are all considered gifts under Medicaid's 5-year look-back policy. These are uncompensated transfers. And so that's where we want to start to do careful planning. Proactive planning is best, but in crisis planning, we can still look to maneuver funds if your POA, that financial POA, allows us to be creative in how we are protecting assets. Exempt asset transfers would be to a spouse. If we have a couple and one spouse is not well, and we want to start to get assets out of that spouse's name, we're going to make a transfer, even within 5 years, from one spouse to the other. You can also make transfers to disabled individuals and minor children, but you can't make transfers outside of the marriage. Non-exempt transfers would be everybody else. If you're paying for the kids to go to Disney World, but you're not going, that's a gift. So we talk about how to spend down. If you are looking to qualify for Medicaid and you're having to spend down to become financially eligible, what does a spend down look like? A natural spend down means that we are using your money for your needs as a couple. Maybe as part of that spend down, we are updating your cabinets and your countertops and the HVAC and the flooring in your house. Maybe we're taking the 1982 Buick that you have and turning that one in and getting the new Chevy truck that you've always wanted. How that spend down works is using your money for your needs. That's a natural spend down. Purchasing a prepaid burial policy. Using that for care needs. That's certainly an acceptable spend down. How we may otherwise make transfers may be depending on whether we're doing proactive planning or crisis planning. Because if we are making a gift or a transfer within that 5-year period, we want to make sure that we're avoiding a penalty. If you are giving money away to people and then applying for Medicaid within 5 years, Medicaid is going to penalize that transfer with what is, I call, a waiting period. That is a length of time that you would otherwise have qualified for Medicaid, but for the transfer or the gift that you had made within that 5-year period. And Medicaid makes you wait until that period is over before Medicaid will pay for your benefits. That penalty only starts when you are otherwise financially eligible. And for married couples, the impact means that that community spouse who got to keep just half and only up to $137,000, they're having to use that money to pay through that penalty period. So knowing some of these rules can be critical to long-term care planning. You don't want to run afoul of these rules and then go apply for Medicaid because you've run out of money. So the way we want to protect assets, that works in 2 ways. Crisis planning, we may want to be able to use annuities or promissory notes to get money out of your hands quickly. This is where we're going to look back to that financial power of attorney and see if we can make gifts, even significant gifts, to get money out of your hands, even before a 5-year look-back period. When we're conducting crisis planning, it's because we don't have 5 years to plan. And so in crisis planning, we don't always have the ability to protect everything. I usually will say here in North Carolina, we can protect real estate most of the time and protect roughly half of the cash assets, but not all. If we're conducting advanced proactive planning, we're probably going to be talking about an irrevocable trust. We talked earlier about that revocable living trust. This one's different. It's a living trust. It's effective during your lifetime because you've created it. But when we're doing proactive planning, it's because we have 5 years to plan, or we have a comfort or cushion of planning around that time frame. And so we often will use an irrevocable trust. That is one where you are not the trustee of this trust, unlike the revocable trust we talked about earlier. Instead, you may want to choose someone that you trust, like an adult child or an organization or other trusted person. These irrevocable trusts are also not ones that you are the beneficiary of. Essentially, you are giving a piece of property to the trust, and you're naming someone else who can receive the income from that trust or the assets from that trust, but it's not you. And that is the biggest hard thing for people to wrap their arms around these irrevocable trusts, are that you don't get to change it either. It is pretty much set in stone. You get the ability to fire the trustee. You may get the ability to live in the home if you've transferred real estate into this trust. But this is a trust that is certainly better than just gifting your house to your kids. It is certainly better and more protective for that piece of property and in meeting your needs. But it is one that is very hard to wrap your arms around if you like to control your property or your assets. But the benefit is that you're also being able to protect that piece of property. You're able to preserve that for your children or your loved ones. It's money that can be liquidated at a later date. When we talk a little bit about that emphasis of aging in place, particularly at home, I really can't underscore the value of what I call a care contract. Sometimes these are called personal needs contracts. This is allowing you to pay someone to come take care of you. And I know that the NEST program has those friendly visits or respite visits, but this is allowing you to pay someone to do some of the heavy lifting that the NEST community may not be able to fulfill for you. So taking you to doctor's appointments, getting you your groceries, doing your laundry, doing your cooking. This is a helpful tool in protecting assets, because with a written contract, Medicaid can't tell you that that was a gift to your adult child who's been doing all that work for you anyway, and would probably have done that work for you out of love and affection, but this allows you to pay that person. And it doesn't have to be a child, it could be a friend, it could be anybody. But this is a care contract, allows you to legally pay people, anyone of your choosing, to provide needs for you, and which allows you to stay at home. And if you did run out of money, and if you did need to apply for Medicaid at a later date, the money that you've transferred to this person under this legally binding care contract cannot be counted against you by Medicaid under the 5-year look-back period or for any other reason. It's not a gift. You are doing it under this legally binding agreement. And this is a wonderful tool in allowing people to stay at home, age in place at home, pass money to people who are already providing care and providing needs to you to allow you to stay at home, gives you independence as much as possible. This is a wonderful tool, whether you are a caretaker or you're the person who needs care. These care contracts are truly a wonderful value in protecting assets. I want to talk a little bit about protecting the house. Most of the time, that is people's most significant asset. There's lots of different ways to protect the house. The reason we want to protect the house, because earlier I said you can own a house up to $605,000 in equity and still qualify for Medicaid. But here's the rest of the story. If you have received Medicaid, or if your spouse has received Medicaid during your lifetime, then later Medicaid can look to claw back the home through that probate process that we talked about. So when someone passes away, Medicaid can make a claim against the estate. And often, if you pass away and your house is your most significant asset that you own when you've passed, even as a Medicaid recipient, Medicaid's going to be one of our first creditors who will want money from the estate. And that's what we call estate recovery. And so a lot of the work we do in asset protection and qualifying for Medicaid is looking for ways to avoid Medicaid's estate recovery. How are we going to protect the house, both for the spouse who stays at home, but also for loved ones? If you want to leave a legacy gift to your heirs, this may be your only asset that you can do that and still qualify for Medicaid. So protecting the house is key. For you all, when you want to age in place, protecting the house is vital. And so avoiding that estate recovery really requires good planning. Whether it's proactive or crisis planning, that makes the difference. So we may do exempt transfers. If you have a disabled person in your life, you can transfer the house and apply for Medicaid the next day. That is even within the 5-year look-back period, someone who is disabled may receive that property. We're still not protecting it on their death, but that may not be the biggest issue for you. That may not be your biggest concern, but you can always make an exempt transfer to a disabled person. You may make an exempt transfer from that spouse to spouse, so giving all of your interest in your home to your spouse. What they do with it is critical, because if we're doing proactive planning, we may say to that spouse who now owns the entire house, let's put it in an irrevocable trust. Let's go protect that piece of property. Don't give it to your kids, not outright at least, because there's some tax implications involved. That's a gift and estate tax issue for you. It also creates some capital gains tax issues for your kids when they do go and sell it. So that irrevocable trust is a way to avoid those issues with taxes and also look to qualify for Medicaid and protect that piece of property. There are other deed transfers that we may do, and those are more crisis planning. I can't underscore, and this is not on the slide, but a caretaker child. So that is an adult child of yours who moves into your home and provides care to you for at least 2 years. This can't be a niece or nephew, it can't be a grandkid, it has to be your child. Under the caretaker exemption of Medicaid, that's an exempt transfer. If you have established that they provided care to you for 2 years, that care kept you out of a nursing home, then you can transfer that house to that child even before the 5-year look-back period. That is an exempt transfer. That is something that is incredibly valuable to allowing you to stay at home because you have an adult child who's willing to move in with you and care for you. That's also when we may use that care contract to help provide care through that process. One of the other deed transfers that we may do is a legacy deed, or what we call them 1% deeds. These are crisis planning moves in my book. This is where we don't have 5 years to plan, but we do have a house that we want to protect. It is not worth protecting if it's not paid off, so I encourage people to try and live debt-free and die debt-free as much as they can. But when we are doing these deed transfers, we are not gifting your property to your kids. We are not adding them to the deed just as a gift of love, because that would run afoul of Medicaid's 5-year look-back period. Instead, we may ask your kids to purchase a small interest in the home and actually pay you that money to join you on the deed. A small interest in the home would be 1%. I like to work with the tax value because that is typically lower than fair market value, at least in this market. And if the kids pay you to join you on the deed, it's not a gift. And they own a small percentage of that piece of property with you. You continue to own the greater percentage. But they join you on that deed. A tenants in common ownership is permitted under Medicaid. We look through different ways to avoid that Medicaid estate recovery, whether that's by using a right of survivorship deed or some other legacy deed. Commonly, these are called ladybird deeds. Not every state allows these. North Carolina does. But typically, these kinds of deeds, at least under our current laws, have been working for decades. I can't envision that they will always work the same way or that these deeds will be grandfathered in the future. And so for that reason alone, I like to use these in crisis planning when we don't have other options. It is an option now, and it is an option that's been working here in Brunswick County, New Hanover County, and Pender for quite some time. So, I have reached the end. So, I'm going to open this up to questions, and I think Meg also has a microphone. And so, if you have a question, Meg can be our Vanna White and offer you the microphone. I'll repeat I guess I don't need to repeat the question.
Actually, if you would just be on the safe side, just
yeah.
for our recording purposes. And just so everybody knows, if you missed anything tonight today, we are recording this and it'll be up on our website, so you can access it or have friends that would like to access it. It'll be up there.
As a word of warning, this is not legal advice. We do not have legal representation or attorney-client privilege right now. This is purely educational. If you ask something that I think requires a little more conversation, I will carefully try not to answer your question or at least guide you in the way that you can get that question answered, but this may not be the forum to answer some personal things.
Okay.
You mentioned that the limit for federal estate tax is $12 million. What is the limit for the state of North Carolina?
That's a great question. So in reiterating and it's actually just over 12 million currently, is the federal gift and estate tax exclusion for this year. I expect it will raise a tiny bit next year. That's the federal gift and estate exemption. We don't have one in North Carolina, so it's good news.
Okay, another question. We talk about a durable power of attorney. Is there such a thing as a power of attorney that's different than a durable power of attorney?
That's a great question. So the reference is to a durable power of attorney, and that's the one that I like to call the financial power of attorney. And the question is there one that's not durable? So the word durable means if someone is incapacitated, this is in effect. And often the word durable power of attorney is intended to say, if I'm incapacitated, this is in effect. North Carolina law in 2018 just has now done away with the requirement that it has to say durable. Now the default is that all powers of attorney created in North Carolina after January 1st, 2018, they're all durable, unless you say it's not. And so most of the time my clients will say, well, why would I want one that's not durable? And I agree. That's a wonderful question when they ask that, because that's the time you want a power of attorney, when you have diminished capacity. So there is a difference. I haven't seen them very often, and I'm not sure I would be recommending a non-durable power of attorney unless the circumstances were just right.
I have one more question.
Okay.
Community Medicaid. I'm a little confused because you talked about half the assets of the couple. I was under the impression that if my husband had full-time medical care because he was ill, dying of cancer, I could today transfer all of his assets in my name, and then we could go on community Medicaid. And those assets, greater than what you stated was the limit of 130, whatever it was, 132. Am I wrong about that?
Yes. So if you're applying for North Carolina Medicaid here, you can certainly transfer assets spouse to spouse. That's an exempt transfer. But if one of you in that couple, one of the spouses looks to qualify for Medicaid, long-term care Medicaid, then that spouse who needs care has to spend their half of the assets down to $2,000. And the other spouse, the community spouse, can only keep that maximum amount of $137,000.
Does that change from state to state?
It changes from state to state. So your figures may have come from other states. That's true.
You mentioned out-of-state power of attorneys.
Yes, sir.
What about out-of-state wills and trusts and estate planning, comprehensive estate planning?
So the question is, if there's an out-of-state healthcare power of attorney or will or trust, how do those factor in if you've now lived in North Carolina? They should be valid here in North Carolina. We have laws that say if it was validly executed in that state, it should be valid here. Now, that's not to say that there won't be some hurdles to cross just to reach that path. One of those hurdles is you may need an attorney in that old state to sign off and say, yes, this was valid when we executed it under these laws. And more frequently, if we have to have that attorney write something to that effect or sign a form to that effect, I'm now getting bills for my client from that attorney. I guess I haven't wised up, because if I have to write those letters, I don't charge people for them, but other attorneys do. And so that may be an unforeseen fee that you might have to get other legal opinions involved just to verify that, yes, they were valid in that state and that North Carolina should accept them too. On a more fundamental level or more practical level, for health especially, if you have a healthcare power of attorney from another state, I would encourage you to at least have one done here in North Carolina. I have heard from several clients who have gotten routine health care at our hospitals here, and when that hospital is asked for the healthcare power of attorney and was presented with an out-of-state document, they wouldn't accept it. And so, as a fundamental level, I think it may be worth getting one done here. They're free, there are forms online for healthcare powers of attorney. You don't have to have an attorney prepare that for you. I like to prepare mine for my clients so that I know that they've got everything they need. Mine's a little different from the state form, but truly, I think as an urgent matter of getting your care needs met, it would be worthwhile to have one done. When you think about trust, and you had mentioned an out-of-state trust, sometimes the only amendment you may need to do is just to simply say, this is now going to apply to North Carolina law as opposed to the old state laws.
Thank you. For the durable power of attorney, do you incorporate language that would include like getting information for what do you need it? For passwords, user IDs, that sort of things, because everything's gotten so digital. It's like, and it's so complicated to even try to get to the asset, unless you know that.
That is a great question. So the question is, how in powers of attorney or trust or wills do you provide access for that fiduciary to access things you own electronically or digitally? The good news is North Carolina thought about that years ago and has the Digital Assets Act, and that would allow people in certain fiduciary positions to access those accounts on your behalf. So even if they didn't know your password, this allows them to reach out to Apple to get your Apple ID or whatever provider on your behalf or your estate's behalf or the trust to get those assets. On a different, more practical level, you might be asking the wrong person how to keep up with password management. I still use the same password for everything, and I know that's not a good idea. But one of the things I'm seeing more and more are people are storing passwords in their phone. I don't know if that's a great idea if your phone got stolen. I see these digital password wallets all the time that I think is probably a useful tool. I think it just requires you to be tech savvy to use them. My clients, I give them an opportunity the old-fashioned way. When they do planning work with me, I provide just a sheet, and we call it the password cheat sheet, where you can actually identify whether it's Amazon or Facebook or whatever online accounts that you might have and the email address that you use. Now, I recognize now that people's passwords are changing far more frequently than they remember to update the sheets, but that can be a great start in identifying what the assets are and how to get into them.
Excuse me, one other question.
Sure.
Can a trust be the owner of a long-term care contract, insurance contract, on an insured?
So the question is, can a long-term care insurance contract allow on the insured a person, can that be owned by a trust? I think why not? I think the hard part would be getting the underwriting to approve that, but I think anything is possible. I haven't seen that. That's not to say that that doesn't exist or can't happen. I think you may have a little trouble with the underwriters, but why not?
I have a question about revocable living trusts. Can 401k accounts and IRA accounts be put into an irrevocable living trust?
Typically, no, or I would not advise that unless we had some very important and different circumstances. Those kinds of assets are subject to being taxed because, in essence, to transfer them to the name of a trust, that funding process requires liquidating those assets and paying the taxes up front on that. So I typically don't fund the trust with those assets during your lifetime. Instead, if we're not doing Medicaid planning and we're using a revocable trust or even an irrevocable trust to receive those funds after your death, you can name the trust as a beneficiary, but I don't advise funding the trust with those assets during your lifetime without some very significant consequences for taxes.
If you create an irrevocable trust, is there a look-back time for Medicaid on that as well as if you just have the resources in your name?
Yes, ma'am. So the question is, if you create an irrevocable trust, is that subject to the 5-year look-back period? The answer is yes. That's why we do proactive planning with that. In some crisis planning, I've used an irrevocable trust to receive a significant gift, but it is still subject to a 5-year look-back period. And so in crisis planning, we may do things a little differently.
So in crisis planning then, is there something like an irrevocable trust that you can put the assets in?
You can use an irrevocable trust during crisis planning too, but we have to be able to plan for that gift around the penalty period. So that crisis planning requires some complexities. You can still use an irrevocable trust for crisis. It's not always the preferred move. Crisis is when we need care right away and we want to qualify for Medicaid sooner than 5 years. We don't have 5 years of assets to pay to qualify after the 5-year look-back period. That's crisis.
But care contracts for someone to actually take care of you, are there limits on what you can pay those people?
No, there are no limits under the care contract. You want to be able to pay people less than fair market value than what a professional would charge. But if you're paying under that fair market value in the community, then that's the limit, really.
I was just wondering, you talked a little bit about adding an adult child to your checking account. What are your feelings on adding an adult child to the deed on your home?
So the question is where I was very cautious about adding kids to bank accounts. How do I feel about adding kids to deeds on the home? I don't want to do it without some guidance from an attorney. If we feel that Medicaid could be an issue in the next 5 years, that's something I would certainly want to guide somebody through. More so than that, I would want to consider the tax ramifications. And so truly that's where I don't think you want to own a piece of property with another person unless you're looking to protect that piece of property. And so in crisis planning, I may look to add kids to deeds. But I would want to be very cautious about tax implications. If that kid's in a shaky marriage, because you don't want that piece of property to be subject to their divorce proceedings. And so how you go about doing that really requires a lot of thought and conversation on what's going to protect you from that kid or their circumstances.
Do you know what the income limits are to qualify for veterans benefits?
Oh gosh, I know that the household income has to be less than the care expenses on a monthly, the medical care expenses. And then on the financial level, the assets of the couple have to be $137,000 or less. It's similar to the Medicaid asset limit. There is a 3-year look-back period from VA.
Thank you.
Any idea just a basic cost for something that's relatively simple?
Yeah, I mean, I think I look at these as a package plan. So when you get a trust with me, and the question for everyone is costs for some of these things, specifically a revocable trust. I include pour-over wills, POAs for health and finance. If I need to do a deed for property, I'll do that. Every attorney is going to charge things differently. For me, it's a $4,000 package. And we would talk through whether it makes sense for you or not, and what other funding needs that you have.
Regarding the care contracts, could you pay your spouse?
So the question is, if we are using a care contract, can we pay our spouse? The answer is yes. You can pay your spouse, but if what we are doing is to start shielding assets from Medicaid. When Medicaid looks at you as a couple, we're just transferring money from one spouse to the other. So it's not as beneficial to do that. And so I make quite a question, what's our goal if we're using a care contract, if we're paying our spouse?